Okay, I have two honors. First one, I get to be the last speaker of the day. Second one, I get to follow Jeff Houston. It's like they hate me, okay? And anyone who gets to follow Jeff, you know you're always going to be second, but it's the way it is. Great presentation. I'm going to go pretty quick, and what I'm going to take up is the fact that we've had a very interesting year in the U.S. government and how it deals with the internet. I'm going to highlight what's happened, and then I'm going to talk a little bit about what might be happening, because we've also had some changes recently. This will be, I'll do some questions at the end, but this is mostly a thought exercise for you folks. Okay, so, let's see if we can get a next page out of this thing. There we go. Okay. Recent internet developments. A couple of things that happened. The big one that happened. Earlier last year, actually a year and a half ago, but finished last year, we had the FCC Open Internet Reclassification Order. For folks who were here yesterday, you got to have lunch with some of the FCC staff, which was very nice. They talked about how to engage with them on open matters and why it's important. Well, this is one of the ones that's going to be a hot button coming up. What they did is they changed the definition of internet broadband service. For the last 30 years, since we've really had an internet service has been an enhanced service. And what's occurred is that as a way of implementing net neutrality, the FCC issued an order which remanded internet service, recategorized it as a basic telecommunication service. So it put it in the same world as, phone lines. Now this is really interesting. When you do that, you pick up a lot of regulation. Everything from how much can you charge? Phone service is something that you file tariffs for, and it's a regulated entity. Obligations for things like contributions to universal access funds and similar things. So what the FCC did is they said, okay, broadband internet service, it's not an enhanced service, it's a basic telecommunication service. And because it is, it's now under our regulation. Aha, very nice. One way to expand your authority is to change the definitions underneath your definition of authority. So now it's suddenly subject to their authority. And then they said, but all of the parts that we don't need, we're going to forbear. We're going to not use. We'll refrain with respect to the internet from several hundred aspects of telecom regulation. The only thing we really want you to do is know you can't block people, you can't throttle people, and you can't engage in paid prioritization. And that is the essence of the 378-page reclassification order, the Open Internet Order. Basically, they said, look, if ISPs somehow interfere and choose winners and losers for their customers, services they can use and services they can't, and do preferences, then we'll hear the complaints about that, and we'll have the ability to act. They set up a process where you could complain. And they said if we set this up and we forbear all of our other authority, it should be enough to do the job. And it probably is, except for the fact that you don't know whether the FCC next year or the year after or 5 years from now might decide to take all of the authority it has, those hundreds of other provisions, and bring them back on the table and use them. So it's an interesting way of getting the job done, and it did work. Regardless of whether you think net neutrality is a good thing or a bad thing, the manner by which it was done is definitely an interesting item worth thinking about, because effectively the internet is now regulated, but they have decided not to exercise all of their rights to do so. In the middle of this, so how do I know about this? Okay, so I do ARIN. ARIN's at IP Registry, you guys know us. And we don't take positions on 99% of this stuff, but we do get asked occasionally how it'll affect the IP number registry. In fact, in this case, we did get asked, and I said, please make sure you don't accidentally change numbers. And so there actually is a statement in the Open Internet Order that specifically says this doesn't change how IP addresses are administered, because you could easily read it as doing otherwise and making it like phone numbers. So they put something into that effect. ARIN doesn't take any position on these because basically every service provider in our region uses ARIN, and some of you feel one way and some of you feel another. So even though we're a trade association, there's very few matters we actually advocate and take a stance on. This open internet reclassification order is likely to be a hot potato in the coming year, and I'll come back and talk about that. There were some other developments. We actually heard about one of these earlier, and I put it here. DMCA Online Designated Agent Registration. So the Digital Millennium Copyright Act, if you have the privilege of receiving takedown notices, you really should go to the Library of Congress and use their online system to register an agent. That's something that's pretty important. Our speaker earlier today, Jennifer, was very nice to point out that if you don't do it and you ignore the notices, you actually do have the ability to lose the safe harbor provisions. So probably don't want to avoid that. Let's see, Section 230 of the CDA. Yeah, so there's this interesting thing going on that people should know about, which is that the Communications Decency Act basically exempted intermediates from content liability. So if all you do is run a bulletin board, but you don't post or edit or refrain the content, then the people who do post are the ones liable for that. That's actually an active discussion right now. There's some cases going on where people who aggregate postings may be held liable. Whether or not those are postings of online services, do you want a massage, or whether or not those are rental listings in San Francisco. Maybe the guy who puts them all together has some liability about what business is being conducted. And there are active court orders going on, court and litigation. And this will affect you because obviously as a service provider, you generally don't worry about the content flowing over, but some of the outcome of this, depending on how it falls, could easily affect a hosting organization and or an ISP. Terms of use violations and computer crime statutes. Yeah, this is another good one. So you should know that we do have a computer crime statute out there in the US, and a lot of other countries have similar. And that computer crime statute basically says that if you attempt to use a system that you're not authorized to, you actually are committing a crime. Now, this is different than violating your contract. You sign up to a website somewhere and you agree to their terms of use and there's a contract there. No, I'm actually talking about if you intentionally use it and you know you're not supposed to. Well, it's come interesting with terms of use because what if you just use it in a way they don't want you to? Like you use a screen scraper to log in, scrape information, and they say, don't use a screen scraper. Are you violating the terms of use, or are you committing a crime? And that's pretty important to know, actually. There's a pretty sizable difference between having a dispute with someone and creating a criminal act. This got clarified in the federal courts last year pretty clearly. You're not committing a crime if you just use something in a way, but you're an authorized, in a way they don't expect, but you're an authorized user. It's not clear in the state cybercrime statutes. So we have some cases going on right now where various states have said it's a crime to do the same thing the federal law does, to use something contrary to the terms of service, and that's a criminal act under state law. This is active in the courts as well. So those are the developments of last year that you folks might want to pay attention to. Let's talk about what we might see. Actually, I seem to have skipped one. Let me go back one. There was one more thing that happened last year. The U.S. government let go of a contract, the IANA functions contract. The IANA functions contract is the long-standing contract between NTIA and ICANN for ICANN to operate the central registries, like that DNS sex-signed root zone that Jeff was talking about, and IPv6, IPv4, 32, and ASN 32 and 64-bit central pools, and the protocol parameter registries where we put things like port numbers and MIME types. This has been done by ICANN nominally at the request of the U.S. government for all of these years. And what happened is over the last 2 years, we've had a process so that instead the respective communities, so the ICANN community for names, the 5 RIRs for numbers, and the protocol, the IETF for the protocol parameter community, are all contracting with ICANN or its affiliate, the PTI affiliate, to do the same thing. And effectively, we put those contracts in place, and NTIA said, we don't need a unique relationship here. the affected communities are all contracting to have this service provided. And they actually let the contracts, they had the cessation of the contract. It ended up ending. No change to what's provided by ICANN, no change in how it's handled. It's just now being done at the request of each of the communities. This was seen by some as a U.S. government internet giveaway. You can do amazing things in politics. If you cover one eye and squint, you can make anything look like anything. Reason I say this is because, well, things are changing in the world, and now I want to go back forward and talk about the coming year. Okay, outlook. So, earlier this year, around January, we had a new administration take office in the U.S. We're actually just a few blocks away. And as a result, it's possible that some of these things will come back on the table. If you're a large organization, you have a public policy department, and they're tracking some of this, and you should meet with them occasionally because they're tracking and pursuing these things, and you're the ones actually building the network in your organization, and you really need to know where each other lives. If you're a small organization, you're the one tracking this, okay? Christian earlier said with the I2 Coalition, it's important to pay attention to these things. You might want to work with some trade associations who track these things and take positions in them because this is pretty important stuff. IANA functions transition. I don't expect that to really come back on the table. I'll be blunt. The U.S. government could issue a contract saying we want to maintain these registries, but we're not sure anyone would answer. And even if someone answered, we're not sure anyone would follow their copy of those registries. So it's kind of hard to, once you've said we're not doing this and other people are doing it and they're getting it done right, it's kind of hard to say, no, I want you all to do it because I say so, not because you say so. So we don't think the IANA functions transition is going to materially change, but you know, law is law. If this gets picked up by the U.S. Congress and laws are passed, you know, abiding by law can change a number of things. FCC Open Internet Reclassification Order. Okay, this is already in a major change. So enforcement is changing, meaning there's circumstances that are not being enforced now. For example, under the Open Internet Order, you could decide that free services, bundled free services, weren't appropriate. We actually do have mobile providers who are offering free access to certain like video services, and they're no longer being pursued by the FCC. The FCC has said basically, we're not looking at this. In fact, we're looking at the whole framework to try to figure out how to do it. We have a new FCC commissioner. The FCC has 5 commissioners. This time 3 are seated. We know the new FCC commissioner chair, Ajit Pai, and his filing for the Open Internet Order, when it was filed in opposition of it, is good reading if you want to understand what the current FCC commissioner thinks of the current Open Internet Order. You can see his comments when he voted against it. We could end up with a circumstance where the FCC just defers enforcing the Open Internet Order. We could also end up in a circumstance where they actually open a proceeding. And we were talking yesterday in the FCC, when the FCC staff were here, once they open a proceeding, it's time to comment. So pay attention, because if a proceeding opens, you would like to get involved. Some of you would like to get involved and make sure that these provisions stay in place. Some of you are going to get involved and say these provisions should go away. But it doesn't matter. The point is, get involved is what's going to be important, because there probably will be a proceeding that revisits part of this. There is a potential for this to end up not an FCC matter. The FCC ends up enforcing communications policy and developing policy within the legal framework. It's possible the legal framework will be reopened. This could all end up in the U.S. Congress. And well, they've got a very busy year ahead of them. This healthcare thing apparently is big, and there's some other things that they need to pick up. But this may still end up being discussed and revisited, in which case it's the same topic, get involved, but it's not the FCC, it's your local congressman, and something to think about. And there's also some discussion. So all of this is about protecting consumers. We actually have an agency in the U.S. government called the Federal Trade Commission that full-time worries about consumer protections. And so there's some thought of whether or not some of these roles aren't an FCC matter anyway. Maybe they should be FTC, which will make for an interesting dynamic. Okay, not going to say much more on that. I guess the last one is there is some increased discussion about network and user attribution. This is driven by some of the cybercrime discussions that we heard earlier this morning. There is a concern that we don't have a way of adequately providing recourse for actions on the internet. It's very hard to hunt down people. The ICANN has a GAC, which is a government advisory committee, and the government committee has a subgroup called the Public Safety Working Group, the PSWG. That URL will get you to them. The PSWG has taken up this matter, and they're interested. They've been working on who-is accuracy for some time. That means DNS who-is. They're now taking up the matter of IP who-is accuracy. And they're saying, look, we're not trying to understand every user of every IP address. What we want to get to is the right ISP so we can actually use lawful order. We can actually serve them an appropriately adjudicated warrant or subpoena, rather than going to an ISP and having them refer them to another ISP who then says they delegated it to a third ISP. Now they've gone and gotten 3 court orders when they actually just wanted to know the serving ISP, the edge ISP. That's going to be an active discussion this year. It may lead to policies being introduced within the regions. It may end up being a discussion that ends up being uplifted and taken out and headed in areas like Congress or the congressional oversight committees. So something to pay attention to. That is my 14-minute whirlwind tour of what's happening in the U.S. government and the internet. I'll take some questions, but I am the last speaker, so let's get this over quick.
Hi, I'm Lee Howard, unaffiliated. John, so you talked about lots of communications and computer industry law. There are other laws that might also affect some of us in the industry. There's something about travel. I don't know exactly what that was about. Is that going to affect ARIN's ability to conduct its business? Or I don't know if anybody wants to talk about whether NANOG would be affected by that if it were reinstated.
Which particular law?
The travel ban.
The travel ban.
Yes.
Well, so we do have a circumstance where the U.S. government currently has a travel ban. It's currently being appealed, and they're trying to actually decide what will be the temporary circumstances before in the months that they'll hear the merits of the travel ban. And that will affect parties. We already know there's an upcoming ICANN meeting. There are people who are concerned about their ability to go to it and come back into the U.S. It's possible that it'll affect ARIN. Our upcoming meeting is New Orleans, and while that's a strange place, it's still within the country.
It's within the country we're currently in. It's not within every country in the ARIN region.
It's not within every country in the ARIN region, but the majority of people attending an ARIN meeting are Canada, US, and the Caribbean, so we're unlikely to be affected. There are other internet governance organizations that are likely to be affected. We don't see that. We will see that coming up in our October meeting because when we get larger meetings, we go with NANOG. NANOG has other attendees. It is possible that it will have implications. But we also don't know whether it will be in effect at that time. So we have to see what happens.
That is part of what I was asking is also, you talked about the other internet governance kinds of organizations where sometimes it's a really good thing to have ARIN staff, sorry, the NANOG sign is right behind you, to have ARIN staff at the, an ICANN meeting or an IGF or something like that. That might affect ARIN's ability to continue to...
Right. We've actually done a quick review with respect to ARIN regarding staff, advisory council, board, attendance. We're pretty good. We don't happen to have an impact, but that's more coincidental of composition than it is. We do know in the case, as I said, of ICANN where there is an impact. But the good news is that we don't see anything immediate for us. And long term, as I said, this is something that's actively being appealed in the courts.
Since I don't see anybody behind me, another kind of quick question. And then we can go home. This is interesting. There's a lot going on. The stuff that the U.S. government does affects a lot of us. But again, both ARIN and NANOG aren't just the U.S. Should we see a review of other governments Like, hey, there's this other government, Canada, there are probably Canadians in the room who would be affected by their laws more than US laws. And there are all these governments in the Caribbean.
Right. So since I was asked to come and talk about the implications of what's happening in the U.S. government, that's why I'm here.
And
but I
we
am
are
happy.
in Washington, D.C., I recognize that too.
We actually do track developments in Canada, U.S., and the other 25 countries in the Caribbean that are in the ARIN region for how they impact ARIN developments. But again, folks, most important thing, we're tracking this to make sure it doesn't interfere with registry operations. We're not advocating, we don't take positions, because if you have every ISP and hosting company participating, you have the full rainbow of views, okay? It's up to you to get involved. But I'm happy to come talk about the other regions if they ever get to the point where they impact us as potentially like the U.S. government is so famous of doing.
Thanks.
Thanks. Any other questions? Going once? Going twice? Thank you for having me.